I'm doing this video in response to my previous video I just did in relationship to discussing a document until just recently. I didn't know how popular that document has been, whereby I guess it's being circulated among many to use it as some sort of a self-determination that hopefully keeps the establishment at bay if they're coming for whatever reason, like council tax or um, asking you to come into court in order to deal with a traffic violation for not using a license or whatever the case. It's a self-determination document, what it is, which means it has nothing to do with law. It's doing what that person's interest is according to how they want to be seen within the system. So I, first of all, like to thank everyone participating. And in fact, if you want to call me whatever you want to, um, whatever label you wanted to judge me at, by all means, let it happen. Let it fly. Let's get it all out. I'm okay to be your backdrop or anything else to throw things out, because this is how we come to terms of all the issues that have been raised over the freeman and sovereign movement, the patriots, the constitutionalists, or uh, other people that are bringing in their cultures or races or creeds or whatever to sort of establish a foundation in order to separate themselves from the impending economic collapse of this system. Not completely collapse, because we're still dealing with interest in land, but we're moving into a new level of a trust. Okay, and that's been discussed in my previous videos, and that's not what we're going to discuss here. So again, thank you. This is how we get everything out in the open and question ourselves. The very first question I have for you is, do you know what is law? That should be the first filter when you look yourself in the mirror, or before you sign any document, before you start writing anything. You should state to yourself, am I using law or I'm not using law? And if you're not using law, then what are you using? Because what you're trying to establish is an agreement, and all law deals with effectively is agreements, rules of action over agreements. That's what you go to court for, to deal with the agreement. But reality is that nothing is known except through the modality of the knower. So when you're going to court and you hate court, or you will never step inside of a court, I get that. But in as much as, if you knew what court was and knew what law was, then court would be something like, would be of value to you, because what you're going to court for is because you can't, come to some sort of agreement or some sort of, measurement to which both parties can agree. So therefore you use a third party to hold that agreement as security. Listen to those words I just used. You're giving the agreement over to the judge to hold as security, so that the agreement could be ascertained to see which party is in wrong or which party is in right, and just to have a determination of how to solve the debate, so in order to keep the peace within the territory these people are in. That's all court essentially is. That's how it's evolved through English law. It's about agreements, and to see who has a right to what, and or have a ability to stop somebody from imposing their will onto another. Okay, so when I went through all the comments, and it's not picking on anyone that's done any comments here, because this is generally always the case in anything I do, whether I do comments in Facebook or other forms of media, or I do my videos, is you're either debating what I'm saying, or you're actually bringing in the belief of what you believe a document is saying, and therefore trying to give value back to the document. I did the video for debate to show you why it has no force or effect, okay, in law. It doesn't say anything. And this is not to pick on anybody, and I almost threw coffee out my nose when I read it, so it's not, I'm not attacking anybody, but when a person said the document, and referring to the document, the Baron of Dave Ward, as have any more greater value than his, the instructions of how to use his hairdryer. And it was just funny because of how it was put. But it's not picking on anybody, because we're all in this together, and we're all trying to get through all the muck and mire that has covered the law, to which no one has ever explained to us, and because we've never been furnished with the law or how to discuss it in the first place. We are now lost within in our own agreements, and we don't even know what those agreements are. Okay, so we're bringing in contract and trust law and say, well, we don't have any obligation because we didn't express any obligation, so there is no contract, there is no trust. So, first of all, the question you need to ask yourself: do you know what law is? I'll guarantee anyone that's using this document, including Dave Ward, doesn't know what law is. He's has totally circumvented the law in trying to get his self-determination recognized. So therefore, you just throw in the court's ability to speak to the matter. To law, but they can speak to the matter in equity in order to address a remedy that you're trying to acquire and trying to get at, but the court has to use the equity, and therefore the equity within those agreements that are available to equity, and as such, then make the determination on that affidavit that you've brought in. Okay, I don't know how long. I'm just going, just putting a video together for how long it's going to take to speak to the matter and to discuss it. So, we'll just see where it ends. But the fact is, you are not even using law in order to remove the idea of the presumption in the first place, to which then throws you into the agreement, and that creates the obligation. So that's to somebody else's comment, who then provided the listeners and people that read all the different variances of what a claim is, what legal is, what a liability is, what an obligation. Those are definitely could be correct, but you're making that correctness within the laws of equity, to which then now you've made the agreement. See what you just did? You say, well, there is no agreement, but you just did it by just writing what you think are the permanent or the predominant features of your interest, to which then is measured in equity, because you're not speaking to law. Because you're speaking to law, then there would be a different set of obligations, as well as a different descriptions and explanations of what people are, what legal interest is, what an equitable interest is, because law can only speak to the subject matter. Okay, that's I've discussed it before. It's constantial with your life, which English law doesn't deal with. It only uses your life in order to affect the legal interest. Your status that you're using within English law or equity, and the subject matter. And all those things then allow the judge to ascertain what's the remedy you're looking for, so that both parties are equal when they go to court. Because I can't go to court, into lower courts of government or the state, because there is no contract or trust. And I can jump onto that real quick. Guess what? There is no contract or trust with government. You don't have any. You can't make one unless you expressly make one with government, and you do that through an oath or whatever else, to hold an agency of some sort, a ministerial position or something to that matter, that you've actually expressing that with government, that you are going to adhere to those duties and powers within that title, or that title that you are holding, so that you can express what it is that law is subject to. For instance, if you are employed with Walmart or any company, but I'm just going to use Walmart. When you go to work at Walmart and you've agreed to it, okay, as soon as you accept a paycheck or you've agreed to it, thereby at that point your absolute rights, dominion, and whatever you want to do, drink coffee when you want to do, or leave work when you want to, um, not abide by the duties and powers of that title, is when you leave the job. But while you're in the job, you are of agreement to it, just like when you're a citizen or you buy property or exchange anything within the system, you're in agreement. So stop saying, well, where's the agreement? The agreement is subject to your rules of actions. You've accepted the privileges in government by your actions. And until your intent is known, because that's your power, your expressibility, that you no longer want to be subject to that agreement, just like you do not want to work for the company anymore, you have to give notice that you are no longer there. That's just how the rules work. Until you do that, then it's voluntary agreement that you've made by your actions to continue to accept the privileges or to be employed. If you show up to work every day at Walmart and you're accepting a paycheck, what are you doing? Okay? And indirectly, if you go into Walmart, you didn't sign any contract with them, just as a patron to go in there and shop. But aren't you not still governed on the rules of that organization while you're in there? To the degree that you're not going to just pick up and do whatever you want and not go through the till, not go through their means in which to make purchase or not make purchase, but maybe just carry items out the door without going through the process. But you didn't sign anything when you walked in there. That's the same thing when you're dealing with government or anything. You didn't sign anything. There is no contract. There is no trust immediately with government. You don't have one. Your agreement is through an operation law, not through an act of parties. And the operation law is holding your land interest in the common law. Okay? That's what we're learning in this English law series, to get down to the brass tacks. You have an agreement through operation of law to make sure your interests are protected. So whenever you make your intent known to no longer be administrated under government, which is administrated under a trust for sale scheme that started in 1925, and everything you're exchanging you don't own, you're assumed owner, you're a quasi-trustee, holding everything as a quasi-trustee, and you're paying for that right for as long as you want to continue to show up to work essentially every morning and hold a citizenship, a driver license, or buy property, or whatever you want to do under government. You're noticing your agreement to it, and until you make your intent known, that has to be expressed. That's your responsibility. If you want to be 100% responsible, that's your responsibility. They're just going to assume that you've made the agreement because, guess what? Maxim law. Ignorance of law is no excuse for violation. So you can't have it both ways. If ignorance of law is no violation, then it must mean that you've made an agreement to be under government because of the very interest that you're holding and are subject to by your own actions. Okay? Why don't we get to some main points? Each person that's made a comment, again, has not debated anything I said. They're not debating. Just read them. Listen to the video I said. I told you the reason why the document had no power. And then read the comments. Or, reflect on how you interpret things. Are you going to debate me on what I brought through the video? Are you debating that, no, Dave, you know what, you're wrong. The Crown and State is blah, blah, blah. Or law is always presumption. It's not strict. It's not settled. So, and here's why. And I'm going to show you. Okay? Until you do that, you're going to circumvent what I'm saying, just like we're circumventing the law by that document. You're actually circumventing the law through that document. Okay? You're not even using law. You're using the arbitrary nature of equity to make your self-determination known, to which then the judge has to see you according to equity. And equity has has use to land under a trust, and therefore the trust rules set precedent. They separate your legal interests from the interests that are administered over by government, who doesn't own any land, can't own land. It's a perpetuity instrument, like the church and like the Jews, the race. they don't own any land, okay? They don't have no control in common law, and then they only have controls of which they've been granted, and those are not common law controls. They are equitable controls to which now you're arguing within to be recognized in through a self-determination document that then automatically overreaches your true rights or security of those rights, okay? Security of those rights in the common law, that if you went to that, you wouldn't even be dealing with a crown or state, okay? For instance, I'm a baron. Well, what does that mean? Essentially, all English law, as I've discussed, is rules of action over rights to estates in land. That's what English law deals with. That's it. And then it measures, it's substantial to your, which I didn't fully finish because I said it had to go through a life, but then it creates a legal personage that creates a set duties and powers that can extend after your life, to which if anyone else takes that obligation, then they're treated the same way based on that title they're holding according to that subject matter. The subject matter creates all those things, the status and the subject matter create the jurisdiction. So if you're arguing within the lower courts of inherent power, again, you're circumventing the law automatically by dealing with those interests within those courts that can only hear you based on that status of subject matter. This, like, if you are, the general manager of Walmart, you're going to deal with a different subject matter and based on the status and duties and powers of that title. But if you are just, the cashier, the frontline worker, your duties and powers are subjugated to that. And sorry, I'm going to shake this once in a while when I move because it's on my the laptop here. So you're going to be measured against the different duties and powers that extend to everyone else equally. That then goes on for as long as Walmart is in power. And you're working within that dynamic. The same thing when you're in English law, there's legal. The only way you can enter into English law is through a legal personage, because it's all titles, and titles are carried on like a university. Just think of the idea of a university. Just think of once a dean passed, you had to start from square one. Okay? That's what fictions are for, to set a stage, set a foundational rock, a cornerstone of duties and powers that when a person takes that title, then they know what obligations are associated with that title, so if anyone wants to affect that duty, whether it be an oath to that duty or somebody want to challenge that duty, then the court can look to the parameters of that obligation that is associated, so that person who holds that title, let's say, doesn't overextend the powers of that title, or if someone wants to affect the duty, they know that power in that of that title is within the parameters of that person in order to get that matter dealt with. It's not, we're making it more complicated than it is, okay? It's common sense. Law is reason. It's logical. That document has no logic in it for the very reasons that I expressed in there, okay? You know what I'm going to do here with this? Cases and notes on land law. Bora Laskin. Let's find out who this guy is, okay? The Honorable Bora Laskin, a Justice of Appeal in the Supreme Court of Ontario, formerly Professor of Law in the Faculty of Law, University of Toronto. Okay? Do you think he knows what law is? And so if he knows what law is, he has certain duties and powers. You better know what law is so that when you're dealing with him, he can then effect appropriate remedy, because that document you'll throw your ass into equity because you don't know what law is. You're already ignorant of the law by the very fact of what you just wrote. So now he's going to deal with you in equity. Therefore, now you've only got those rights and obligations and powers. Obligations. He's now going to perform an obligation based on those duties and powers that are available to you within equity, which is the second level use to land and a third level use to land to which a citizen has. Okay? He's got to see you in that manner, and then now you're at the lowest level. And that's why you are not being heard, because you're not speaking to the law. He can't help you. You didn't bring in the law in order to deal with anything. You brought in your ideas and opinions and concepts and self-determinations that, hey, he can't deal with emotion, first of all, because law has nothing to do with emotion. Okay, leave that for trials and juries and facts. Juries don't deal with law. They deal with the facts presented under the law, and then people can deal with their emotions and feelings and so forth. That has nothing to do with law. So now you got to go to the law and go to a point of law, and that law, then the judge can say, thank you for bringing that to me, that law, so now I can create a remedy based on your status and your obligations to be before to what you should receive based on the parameters of what you're bringing into court. Okay, I'm going to bring just 2 points here. Chapter 2, possessory states. I'm going to say possessory states. Some words, as you already know by listening to me, I'm not great at. Okay, doctrine of estates. The tenure features of the feudal system emphasize that a person holds land but does not own it. True. After clia emptoris, the holding would come more and more to be only of the crown. Okay? Let's go into another point. I'm going to bring these points to Chapter 3, estates in fee simple. That's the only thing that you can hold as a freehold under government is estates in fee simple absolute. Okay? And that gives you a full right to trade those estates in equity, not in common law. Government doesn't deal with the common law, has no rights in common law at all. They deal with a second level of use to land. They administrate over the waste that's created while in the use of the land and are responsible for the accounting of that waste while its enfranchisements, the citizens use the land under the same trust instrument. Okay? So it says right here, the characteristics and mode of creation. The largest or highest of the freehold estates is the fee simple, which, to paraphrase Plunkett, Concise History of the Common Law, 5th edition, was inheritable by primogeniture from about 1200 AD. Was 1200 AD on, was inalienable without consent of presumptive heirs from about the same time, and became freely alienable without the Lord's consent after the statute of clia emptoris of 1290. It still retains the characteristics of inheritability. Inheritability is also divisible by will. The holder of an estate in fee simple absolute is, to all intents and purposes, an absolute owner, although technically he is a mere tenant of the crown. Okay? I think I missed something. Still retains the characteristics of inheritability. Oh yeah, subject now to particular rules of intestate succession and alienability, and in addition is also divisible by will. Sorry, I missed that sentence. That's why it didn't make much sense there. The holder of an estate in fee simple absolute is, to all intents and purposes, an absolute owner. There you are. Right now you're an absolute owner of an fee simple absolute title under the government. You are. But what does that mean? Because that means by that simple interest, you don't have any rights in English common law. You've overreached that right to become an absolute owner of fee simple absolute under a trust for sale scheme, to which then the government administrates over. And is absolute owner, although technically he is a mere tenant of the crown. It's stating right there in both of those paragraphs I read that, first of all, the only way that you enter English law, I'm going to develop it a little bit more because I already said it, is that you have to be a tenant. You cannot hold any land interest in English common law or in equity law without being a tenant. It's called a tenant for life. the Settle Land Act, 1925. That sets the duties and powers of a tenant for life. And it shows you what interest that a tenant for life holds, what interest a statutory owner holds, what a trustee holds, what a representative, a personal representative holds. Okay, it sets the foundations of the settlement of land. Did you know that? And did you know that you're making a voluntary agreement by your very actions to hold land, into which then you're trying to control that land, that, you know, no one has a right to do this and do that. Well, what interest do you hold in the first place? Do you think that you have also a self-determinable right to now, you know, with a shotgun, hold that interest in land when you have already agreed by its own possession to hold an equitable interest in land under a trust for sale scheme? So that's how you make an agreement. The court looks to the agreement. That's all a court does. And if you don't like court, it's because you don't understand what law is. And you don't understand the agreements you're in. And you're already in agreement by the very conversation you're trying to make here of, or anybody making, about what interest they think they hold. What interest do you hold? Do you hold one in common law? And there we go. I'm a baron. Really? Well, what's your legal interest, baron? Or baroness? Show me your legal interest. Because a baron is only measured against the legal interest they hold. Because a baron is substantial to that legal interest. It's not, you can't just be, I'm a baron, and just float around with nothing. Because a baron is associated with the legal interest entitled to land, which is held in common law. Those are those lords temporal. Lords commons are the agreements of the right to use to land as a second level. Well, those in government hold a second level use to land in equity, not the common law. They have no rights to common law or the interest of a baron in the first place. Okay, a baron has a completely different interest to which they don't have any rights to repeal, charge, go against, or anything else. That's an agreement between the monarchy and the baron, not between government. Government then holds those rights of equitable interest in commons to use those land interests that are held in common law, such as those titles held as a baron, to now essentially lease off that title to create then legal interest that then are made available to those who want to be quasi-trustees, which are citizens who are essentially people who don't want to control land as a common law interest as a baron. So when you say I'm a baron, a baroness, well, go and show the rest of the people your legal title. Go ahead. You don't have it. And if you have it, I'm going to tell you right now, you would not be making a document like that, because there's no need to now create an agreement with the state or crown, because there isn't one in the first place. Your agreement through an operation of law actually was first established through an operation of law, but now you've established it through families and bloodlines and laws of inheritance to control whatever land interest you have. And that is between you and the monarchy and the common law, or now more so to the high courts of inherent jurisdiction. Not those courts that after are given inherent powers to create jurisdiction over the procedures over that territory. See, it's again different levels. So it's an oxymoron to say I'm a baron or a baroness and say I'll never step in a court, because then, well, for the reasons I've already said, but here's another reason. The courts are looking to the agreement. You pass on the agreement to the court then holds the security to make sure that if somebody comes and tries to usurp your legal title, or your heirs are fighting over the rights of that title, and remember, there's no heir to living, so they don't even have anything. They only have something when the estate is complete, and the death of whoever's holding that estate interest in common law, first of all, has to die and then move on. Now the heirs become recognized, but the court's got to look, it's got to be there to address any issues that are created between the transfer of that legal title. So there's no fighting, because the court's there to maintain the peace. And obviously, people not understanding their rights then will create problems, or they don't understand the agreement. Let's say simply just something's unclear. Well, we can't come to clarity. We have to go to court. And the court will look to the agreement to make sure, well, first of all, what law is that agreement under? And then that agreement then, based on your status, is measured how he can now provide redress for the issue that you have. That's what a court there for. They're not your enemy. Your enemy is yourself. If you knew that you're right, why would you not go to court? Or if you're uncertain if you're right, then why would you not go to court? No one is your enemy. You're the enemy. For the very fact that document is complete and utter issues with commingling what a baron is, bringing in a resident as an address, which is a relative to a property agreed through under government, then intercoursing with a crown estate to which you have no contract with or trust with in the first place, to then say there's no fucking law, to then say all law is presumptive, well, then you're brought in equity, because equity is presumptive, to which law is actually settled, which is the common law held in the monarchy, and that's why the monarchy can do no wrong. If you're dealing with a crown, you're not dealing with your interest with the monarchy. Through an operation of law, you're dealing with, when I say the monarchy, I'm talking about that chattel that sits on the throne for all sightseers to look at. The Game of Thrones, the movie, the series, whatever, I meant to say, is about everyone wanting the Iron Throne. Okay? Because that is what holds the land interest. They're after fighting over land. They're not fighting over people. People are just a cannon fodder within that interest for people to fight for that throne. But you don't need to fight for that throne because it's already been settled, into which was the ending essentially of the Game of Thrones series. Is what happened, and I'm Sensei or whatever her name is, it's been a long time since I watched it, she was holding, you know what, I'm going to hold the common law interest in the north. Okay? That's what, and the rest of you, so what government now, and lords and stuff like that, are going to now create sort of a democracy to then control all those other interests under the Iron Throne. Do you see? It's exactly the same as happening today. And you guys, I shouldn't just say blanket statement you guys, because some of you guys are not doing it. You know what law is, or starting to learn what law is you're fighting under all those interests under that equitable agreement to which those new parties are holding. You're not dealing with the Iron Throne, to which is not the holder of the land anymore. It's the vehicle, the vessel, the powers and duties, the prohibitions and limitations holded to that throne. So then when you're dealing with it, you're not dealing with the, Queen Elizabeth herself as the physical life that's holding that interest directly, immediately, but you're holding that title that holds that right, to which those rights and prohibitions and so forth are locked in. So when you want to deal with your legal interest, the court can go to that matter, to which then is held, and that's why the monarchy can do no wrong. Okay, only the ministers can do wrong with the misinterpretation of law, because the law is already settled. You're just going in there to deal with that matter. Because you have dominion right, and dominion right can never be transferred. It can be taken away because you break the law. Okay, you do something against the law, like murder somebody. It's thou shalt not murder. It's not thou shalt not kill. Thou shalt not murder. And that shall create harm in its essence. There's only about 3 commandments that make any sense on that whole damn thing in the first place. Okay, it's confusion is the driver. It's ignorance of what law is essentially what democracy is. It's democracy, it's mob rule, and mob rule is the entire level of awareness of its participants that are voting within democracy, which is essentially ignorance to what they're doing, to which the politicians are on a different level of ignorance that are then only dealing with that matter that they've been given a right to, because they've been set with certain legal duty or certain duties and powers to only administrate over that right, to which they have no rights to the common law and your dominion interests, which are held before, to which you have a right to, because no one's ever taken away, because you've never broken the law, if you're not in prison for murder right now. But if you've never broken the law, then you still have dominion interest, because that's can never be transferred, and English law has no rights to deal with, because, and that's the problem with self-determinations. No one's arguing you have dominion. That's not even a question. The only thing that English law is dealing with, and maybe I can close this now, is looking to the agreement. And that creates the obligation, people. What agreements are you making? Because no one's questioning whether you're alive. It's like sitting down to a board game. Is anyone questioning whether you're alive? No, you're dealing with a token to move around the board. No one's saying whether you're alive. Obviously, you're the power that's moving that thing around the board. But at that point, we're not going to your interest of a life sentient being at that moment. You're dealing with the rules and obligations that that token has when you're moving across the board. That's it. So stop doing it. And stop making these documents. You think that document has any power? I'm telling you right now. If you think a document, here's a good idea. If you think that document has power, I challenge anybody to go into a civil court. Okay, and the only way you can deal with any issues of jurisdiction is go through the civil court and then speak to the judge on that document. Go ahead. Because subject matter, right? We just already talked about jurisdiction. Go ahead. If you want to change your jurisdiction, bring that document to a civil court. Go ahead. First of all, you bring it to a lower court. It's like I said, he's in his mind. He's probably reliving his second shot on the ninth tee. You're not saying anything. That's why he'll let you go on, and I've seen this in somebody's expressing all of these rights and obligations. We're going, judge is going, geez, I wonder if I add a simple orange glaze to my turkey, I'll bring out some more. Maybe I'll add some. And that golf shot that I had, that's all he's doing. The moment you spoke, he's giving you the right to speak and bury yourself, and then you go, okay, well, yeah, thank you for that. Now we're going to set a trial date for this time. And he's talking to his clerk to set up that date. You're not saying anything. I know it. I went through it. I've been through into different courts. I've had went through 5 judges before they flew one in, and I didn't know anything at that time. Okay, I spent time in jail. I took my beating, and every single time, guess what? It was my fault. I know it. Every single time, it's 100% responsibility. So go ahead. I challenge any one of you. Anna von Reitz, I challenge you. Bring in any of your documents in. I'm going to actually do a quick video on Anna von Reitz right now of a document I just received, and I'm going to blow that apart. Because you're not... No, I've already beat the thing to death, okay? I don't even know what I was going on about that last little bit, but... I'm just telling you the facts. Anyone. You bring anyone to me. Bring your baddest lawyer. And he can't speak to me. Because he can't speak to the law. He doesn't know what law is. And if I'm speaking to a judge and a learned judge, we wouldn't be speaking about this matter. We'd be speaking in private concerning the matter, which I'm doing right now. Okay? Bring in any guru. I don't care. The biggest, baddest one. The one who's got the most hit or likes. Bring in Jordan Peterson. And I'll tell you the reason why he's having problems. Bring it in. Okay? You have way more power than you could even absolutely realize. There's no one more powerful than I am in the world. Not one. Because I don't deal with the world. I know what the world is. You have that same power. But you are not exercising it because you don't know what that power is. Obviously by the documents such as that. If you want to use a document or any document, you should ask your question. Look in the mirror and say, do I know what law is? And that's your answer. And with that, have yourself a great day. God bless. Take time to like or not like. I don't care. Throw something, whatever. But if you're going to debate me, debate me. debate what I'm talking about. Don't bring in your beliefs in. Your beliefs about what you think the document says doesn't debate what I'm saying. You're just giving power to your own misunderstandings of what law is.